Okay, so I know you touched on this a little bit, but once a person's secured a patent, how can an inventor leverage it? And what is typically done to enforce the patent? So I've heard a lot of people say things like, your patent's only as good as, your ability to litigate on its behalf and enforce it and those kind of things. So can you just kind of go through what that process looks like, what inventors need to know?
Okay, yep. I guess the first is stepping back a little bit. The first thing that inventors typically have to look at is what's your end goal? Do you want to commercialize it yourself? Do you want to start producing it in your garage and build off of that and create, a company based upon that?
You don't have to use your garage, by the way. You can come here. Just saying. All right.
Good point. But, is it something that you want to try to sell to others that are already in that business? Maybe you come up with a better helmet that prevents concussions, and so you would potentially, instead of competing against the helmet manufacturers that are already out there, you'd approach them, say, look, I've got a patent on this, I want to sell it essentially. You can either, at that point, where your end goal, regardless of which route you go, is to monetize and to make money on your invention. So that may be through the licensing process, which we've talked a little bit about, where you derive a royalty based upon each unit sold or produced or whatever the terms of the license may be. It may be that you just outright sell it and assign it to a company. Maybe they'll pay you a lump sum, they see the value instantly, and basically they'll buy you out, and then you assign all your rights to them, and then you're out of the process. The license agreement kind of protects a lot of the manufacturers in that fashion, because they may give you a small lump sum up front to kind of help you recoup some of the costs that you already have into it, but also then provide you a revenue stream coming in. So that's one of the ways that they can move forward. But the biggest thing is, once you've obtained your patent, you need to really be sure to police, kind of see what's out there, make sure if you see something that looks like it, could potentially infringe, that's when you talk to us, or try to determine, do the claims, read on the other item that's out there, and can you then go ahead and try to enforce your rights that way. Sometimes it just simply takes, a cease and desist letter. Hey, you might not have been aware of our patent rights here, and send them a copy of the patent. But in some cases, then you have to go on and unfortunately litigate. And a lot of how that goes depends a lot of times on who you're dealing with. If it's a large corporation or another individual, that could change what route you take there. Yeah. So I don't know if that...
No, that's good. Can you just really briefly explain claims for those who might not understand kind of what that means? And
yeah, I mean, I touched briefly on it before, but essentially, and this is where I think you're better off working with someone like us, because again, your claims define in words what your legal protection is going to be, and it seems counterintuitive when you first sit down to start writing, because everybody wants to write in there, okay, all this detail about your invention. But you want broad coverage. I mean, I always draw a little picture on the back of my tablets when I'm talking to people for the first time. Your invention is a speck in the middle of that tablet, and the coverage that you might be entitled to might be the rest of the tablet or a good portion of that. Oftentimes you might have little corners or whatever that are cut out by other art that's out there, other inventions that are already out there that might be close, and so the trick is to fill in as much of that empty space as possible and give you that broadest protection. And again, if someone sits down to write a claim for the first time, you want to put detail in there. If you're talking about an automobile with a very complex invention, but 4 wheels, a body, and some kind of prime mover, that's as broad as you can get. Well, start putting in it has to have 4 doors and glass windshield and stop lights, headlights, all this other stuff that, yeah, it's there, but it's not kind of the main crux of the invention. So that's where it typically pays for you to come to somebody like us, because again, it's a little bit of an art to claim things as broadly as possible. In one word, I mean, what does adjacent mean? Something that's been litigated a number of times.
Yeah.
And, does it have to be touching? Is it spaced apart from? I mean, so you really have to be careful, because again, one word can mean the difference between,
Yep.
infringement, non-infringement, and could, it's a very successful invention, mean millions of dollars to you. So it's a pretty important thing. So.
Yeah, and that's why I thank you for going into it a little deeper, because I really want you guys to understand, everything you're doing on this front end is you're going to be affected by it on the back
And
end.
the rest of the patent application, I mean, it's basically just a how-to manual. It's,
Yeah.
what it is, what it does, how it works is what you're trying to describe. But the claims is where you can really zoom in. And I think it was mentioned earlier, is it going to be directed towards the process? Is it going to be directed towards how it's used? Is it going to be directed towards the structure of the invention itself? So there's a lot of thought that has to go into developing that.
Did you guys have anything to add to that question?
I mean, I guess what I would say is that sometimes I hear misconception about the patent process. So some people don't necessarily understand that when you file a patent application, it doesn't necessarily mean that you have a right to enforce. You really don't have a right to enforce until your patent is issued by the USPTO. So prosecution is often used in the process of obtaining a patent, where you go back and forth with the patent office to refine your claims to get the ultimate allowable subject matter. So I have a lot of people that approach me and say, why are we prosecuting our patent? And I mean, when we're prosecuting our patent, we're really just working toward getting a patent allowed. We're not enforcing it at that point in time.
Your desire is to get those broad claims, so when you file a patent application initially, you're filing based upon the entire tablet, and the entire time you're working with the patent office, you're further narrowing it or changing language to an acceptable form.
So when you turn it in, it's not written in stone.
Correct. And it's not enforceable.
Gotcha.